Supreme Court of India K. Vadivel vs. K. Shanthi and others decided on September 30, 2024 SCC Online SC 2643 Facts of the case. On 31 March 2013, a FIR was registered on the complaint given by one Padikasu stating that when he along with the deceased Kumar were doing their morning walk around 5 a.m. and were returning back, 3 persons alighted from a car with weapons and hacked to death the deceased Kumar on December 20, 2016. Prosecution witness 1 Padikasu was examined. On 25 July 2019, prosecution witness 1 Padikasu was recalled at the behest of accused A1 and A2. On October 19, 2019, on the conclusion of the trial, final arguments were heard, and the case was fixed for filing of written arguments. On October 22, 2019, respondent number 1, examined as prosecution witness 2/wife of the deceased. Filed under Section 311 of the CRPC, she contended that prosecution witness 1, Padikasu has given false evidence, that the investigating officer has failed to inquire the proper eyewitnesses, that the direct eyewitnesses to the occurrence, K. Ganesh son of Kumar, P. Karmagam son of Periyakaruppan, K. Rajendran son of Kasi, Sembilingam son of Padikasu and C. Andiappan son of Chennaya have not been examined and that they deserve to be summoned. She prayed that the additional witnesses be summoned and examined. The accused opposed the Section 311 petition by pointing out the delay of 6 years and 9 months in filing the petition and also about respondent number 1, prosecution witness 2, not whispering about any of these facts during her examination. They contended that the persons sought to be examined were none other than her son, brother, brothers-in-law and other close relatives. The trial judge dismissed the application filed by respondent number 1. High Court dismissed the petition, ordered further investigation in the matter. Findings of the court. In the present case, though the trial judge rejected the application, the High Court has ordered further investigation. The further investigation cannot be permitted to do a fishing and roving inquiry when the police had already filed a charge sheet and the very applicant for further investigation, in this case respondent number 1, has not whispered about anything new in her evidence as is now sought to be averred in the application. There must be some reasonable basis which should trigger the application for further investigation so that the court is able to arrive at a satisfaction that ends of justice require the ordering/permitting of further investigation. We are convinced that ordering the additional charge sheet to be taken on record at this stage pursuant to the further investigation will not be in accordance with law. It will be contrary to the settled principles as laid down by this court. We have also to satisfy ourselves examined the additional charge sheet placed before us, in fact, seeking the examination of these 5 witnesses mentioned herein above. First respondent filed application under Section 311 CRPC, which came to be dismissed by the trial court on November 29, 2019 and was confirmed by the High Court. The application under Section 311 CRPC itself was filed on 22th October 2019, that is after a period of about 6 years after the filing of the charge sheet. It is only when the High Court dismissed her petition under Section 311 CRPC stating that she had not made any prayer for further investigation that she filed the present application in January 2020. At the stage when she filed the application for further investigation, the accused had concluded oral arguments and had also filed written arguments. The High Court has not recorded any reason whatsoever and has not set out any legal principle which is relevant and applicable to the facts. All that is said is the Section 311 petition of the respondent number 1 has been denied on the ground that she has not filed a petition for further investigation. That denial of relief would cause prejudice to respondent number 1. That prosecution witness -1 has turned hostile and that being a murder case, it is decided to order for further investigation. Not one of the legal principles adverted to herein above has been considered by the court as pointed out herein above. The failure to claim further investigation at that stage was not the only basis for the High Court to reject the revision against the dismissal of the Section 311 application. The High Court had given other detailed reasons also, like prosecution witness -1 and prosecution witness -2 not whispering about the additional witnesses. When they deposed in court, the FIR was filed on March 31, 2013 and the charge sheet on July 11, 2013. At the fag end of the trial in October 2019, on the eve of the final arguments, the first round of applications under Section 311 of CRPC came to be filed, which culminated in its dismissal in December 2019. We further direct that, in view of the dismissal of the application, the additional charge sheet dated 2 December 2021 will not be taken on record. The appeal is, accordingly, allowed. We direct that after hearing arguments of parties afresh, the trial should be concluded and judgment pronounced within 8 weeks from today.